Courtney Agrusa and McKenna Rivers on this one. They are experts in this area. They've taken so much time to look at this. It's unbelievable how much can go. We could sit here probably all day long and talk about how to properly classify employees and independent contractors. And I say that because our friends in the federal government seem to not understand themselves what the rules are. They keep arguing with themselves. The same person in the same seat and title will change from year to year. And different agencies have different views of what this is. And that puts us in the middle as employers. What the heck are we supposed to do? And how do we address it? Some of this is pretty simple. Some of it is gray. And some of it is you got to understand what the industry is and what's going on. And we segue from talking about these non-competes. And I will tell you that non-compete agreements against an independent contractor could put you in a position of a problem that you didn't even know existed. It could be enforceable. You could draft it right and all that. But if you get the person wrong, if you don't know who's your employee and who's your contractor, you have a problem. And the question is, who's your boss, right? And so I want to talk a little bit about this. First, McKenna, if you could tell us a little bit about what is an independent contractor versus an employee. And I think a lot of times people always say, well, that's that's an independent contractor employee, or that's an independent employee. Those don't seem to be the right terms mixed together, but can you tell us a little bit about that?
Yeah. Well, good morning, Cliff. Yeah, I think you hit the nail on the head. There's a lot of people who kind of misidentify employees here. Really want to back up. An independent contractor and an employee are both workers who are hired to perform some specific task or to fill a role. The difference is, and really what the core of the distinction here is the relationship of that worker to the employer. So on one end, you have an employee who has a very close relationship to the employer. And on the other, you have an independent contractor who has more of an arm's length relationship. And you might be familiar with the phrase, if it walks like a duck and quacks like a duck, it's probably a duck. It's very similar here. A lot of employers, they say, well, I have a 1099, or the employee has a contract, so they're an independent contractor. But the law looks beyond that to identify who's an independent contractor versus employee, and says that regardless of if you have a 1099 or they have a contract, if they act like an independent contractor, they likely are one. And we'll go into the details a little bit more on that later.
Yeah, so the question I get a lot of times is, well, they wanted to be an independent contractor, right? That's what they wanted. They wanted to get paid this way. It's okay. We all agreed. By the way, this is what everybody does. So everybody, all my competitors are doing this, so it's okay. But what you're saying, it sounds like, is not so fast. You got to look at what they do and what that relationship is, right? Isn't that what the goal is? And so, to that, what are the advantages? And a lot of people say, okay, what is an independent contractor? What's an employee? But what are the advantages of both? Can you tell us if is there something that we're missing sometimes when we just say, well, we'll just make him an independent contractor? But why? What's the point?
It's any secret that when you become an employer and start taking on employees, it comes with a lot more work. You have to manage that employee, set their hours. There's certain tax deductions that you have to make from their paychecks. Getting in later, what we're going to talk about, ESTA, maybe tracking their hours and giving them sick time, also opens up the employer to liabilities for certain employee protections they have. So I think one of the advantages of having an independent contractor is that arm length relationship. It not only creates a little bit of protection from certain liabilities to some extent, but it also takes away some of the added work that comes with managing employees and going through all of those steps. And I think that's where we come into a lot of these issues. I see a lot with small employers when they want to make the jump from being owned and operated by just a few people to taking on employees. They say, oh, well, I'm just going to 1099, or I'm just going to give them contracts, or we're going to call them independent contractors so that I don't have to deal with it, because the amount of time and energy that goes into managing employees is just too much.
Right. Okay. Well, that makes a lot of sense. There's an ease factor. There's some other issues. Of course, one thing that people don't understand though is that you might lose a little control. And Courtney, uh, that's something that sometimes people want a little bit of both ends, right? They want to both have this
Absolutely.
opportunity to not pay taxes,
Mhm.
to just go out there, not have these added additional burdens and obligations under the law, but they also want to tell people what to do. And so, can you just today, as of today, tell us a little about what are the rules? How do we know when a person is an independent contractor or not? Because I know that this has been shifting tremendously. If we were to sit here last year at this time, we were looking at something coming down that was a rule that was supposed to be in place, but I'm not sure that's in place right now. What's going on?
Yeah, so I'm definitely going to touch on that. So just from a general perspective, when you're analyzing whether a worker is an employee or an independent contractor under the Fair Labor Standards Act, there are several tests you're supposed to look at, right? The two most common ones are the ABC test, which some of you have probably already heard of, and then there's the economic realities test. For purposes of this conversation and then the final rule you're mentioning, we're just going to focus on the economic realities test because that's the one predominantly relied upon here in Michigan. And the ABC test hasn't actually been adopted by the US Department of Labor. So the economic realities test, this is the one that's been going through a lot of peaks and valleys over the past year. It looks at multiple factors to see whether a worker is economically dependent on a potential employer for their livelihood. So that's like a very fancy way of saying, we got to figure out whether or not there's an employment relationship that actually exists, right? So before I dive into those factors, I'm going to go back to some of those peaks and valleys we talked about. So in January of last year, January 2024, the Department of Labor published a final rule that essentially revised the standards that are under the economic reality test. The goal was to align them with the Fair Labor Standards Act as it's been interpreted over the years through the court system, right? They're looking at judicial precedents. So they announced that they're going to change the economic reality test. They published the rule and it went into effect March 11th, 2024. Well, with any change comes growing pains, right? And immediately employers were upset because they didn't like how the standards were in place. It was too broad. Suddenly it put people in a position where they could look outside of the scope of the factors that were in place, and lawsuits, right? Lawsuits happen. So there's a lot of legal action pending in the federal courts right now. That's caused a whirlwind as a result of all that litigation. And Cliff, you've been monitoring this too, I know, so feel free to chime in. The Department of Labor, as of May 1st of this year, issued a field bulletin indicating that they're no longer going to be enforcing the final rule, right? So they're not going to be enforcing it. It doesn't make it go away. They're just not going to be enforcing it. And I'll get into a caveat about that in a little bit. So instead, in the interim, while they're kind of working through the growing pains, they have decided to reinforce what they've called fact sheet number 13, which is from July of 2008. So we're taking it way back in terms of the economic reality test application, right? July 2008 is the new standard. If you look at that, it has similar factors to what was included in the final rule. It's not a perfect overlap, but there's 7 criteria. I don't think we need to go through all of them today, unless you guys love hearing me talk, and then I'll be happy to dive into it.
Well, like I said, we could go all day on the analysis, but I think that the key to everyone wants to hear about is that what are some of the key things that we need to know about if we're at risk, right? I mean, there's a lot of factors of the test, but the test, as if we sit here today, do we know what it is and what are the general factors of that?
Well, if we're relying on fact sheet number 13, like I said, it's a 7 non-exclusive factor test that you have to look at. And some of the factors look at, the permanency of the relationship, right? So are you doing sporadic work for this employer or this principal business? Or are you providing fixed work during fixed work periods? What's the nature and degree of control by the principal business? So basically, do they have say-so over your hiring practices, your firing practices, your scheduling, pay rate, establishment, things like that? opportunities for profit or loss from the worker's perspective. So those kinds of big picture items. There's also even a factor, excuse me, for like the skill and initiative required by the worker as provided to the principal. So they're pretty solid factors. But I just want to go back because I do think it's important. While the DOL is instructing us to use this fact sheet number 13 as our, 7 factors, they will, or they have reserved for themselves the option to enforce the final rule if the circumstances permit it. So it puts us kind of in a limbo in terms of what could happen if things progress. So we're going to continue to monitor that pretty closely in the interim.
Courtney, you're saying to everybody that the federal government passed a law, went through a full fact-finding, months-long process to enact a brand new law. Part of that rule that they enacted would say things such as this. If you're an owner-operator of a truck, there's a hard time that you're going to be able to make that to say that you're actually an independent contractor. I mean, there are rules in here about even if your contract says that you could express some sort of control over somebody, but you've never done it in 25 years, that could be an indication that you actually are an employer. I mean, this was a fundamental change in the rule that you're saying is now not being enforced, but actually might be enforced.
Yeah. Talk about confusing.
I mean, it's a massive change. And so that everybody understands under this rule, they went down all the different qualifications. And one of those that they looked at was, what is it that you actually are doing? Is it a big part? Is it an integral part of your business? So, for instance, if I have a business that makes parts and you come in and you help me make the part, that could be an integral part of your business. Now, it's not the only way that you become an independent contractor, but that's against you as opposed to something else. Now, that would be a big deal. So you couldn't just have an independent contractor that comes in on the side. It's a bigger issue. There are things that would look at the profit and loss. They will look at, are you actually engaging? What's your qualifications? All those things. To a certain degree, everything's the same. It's just it was actually more specific. We don't know. But then there's other agencies. You talk about the Fair Labor Standards Act. That's for people wanting to know whether or not they should classify a person as an employee for overtime. But the question would be, or in other wages, and how about unemployment? But they have something called an IRS 20-factor test. That's a little bit different because under the FLSA and the DOL, they don't necessarily look at whether you have an employment agreement. I think McKenna hit it on the head when she said if it walks like a duck and it talks like a duck, it's probably a duck. But the unemployment office might look at, well, you don't have an employment agreement. You don't look like you have a website, so you're holding yourself out for business. It looks like you're dependent upon this one employer. So we're going to look at these 20 factors, and the IRS doesn't even use that IRS test. They use a different test.
Exactly.
And then I understand the AG's office, the Attorney General's office, has a special division looking at wage theft, including whether you're not paying people properly by classifying them as independent contractor, and they'll look at it, even though there's all these questions in the air about which rule to do. So I think at the end of the day, we have rules. There's a general rule that's the most probably specific. If you're good by the one that was passed, you're good by probably all of them. We have the relaxed 2008 rule that's being applied, and then the courts could do what they want to do. Right? Because the courts have historically looked at it, and that's what the rule is. But control, independence, are you truly, and we need to take a look at this we can't just say we've done it in the past this way, so it's okay, is what you're trying to say, is we've got to evaluate. It's very sophisticated analysis. It's not a really easy button that we push, right?
Not at all. It's not easy at all. You have to really do a deep dive into your policies and your practices and the relationship with that person and make an assessment accordingly. You can't just put a blanket on it and say, yep, you're an independent contractor. Yep, you're an employee. There's a lot of steps to it.
Job titles aren't going to make the decision, right? Having a contract where the person says, I agree, I'm not. All right. Enforcing non-compete agreements against an independent contractor. In the new rules that were passed, it said if you require the person to do anything more than the law requires you to do, even one step more, that could be an indication that you're exerting too much control. Here's my handbook, independent contractor. Those are the rules that I want you to apply. you might have some problems, right? So it's very sophisticated. We help people out with this all the time. We go through these, it's analysis. But why will we do that? What's the use of doing all this? What's the risk? Let's say you get it wrong. What's really the problem if you misclassify somebody?
I would say most misclassifications are innocent, right? I don't think people intentionally try to misclassify, although obviously, like McKenna was saying, there's a lot of advantages for an employer to classify somebody as an independent contractor. I think for the most part, though, people really do try to get it right. But there are risks. So if somebody determines that they've been misclassified as an independent contractor, but they're actually an employee, they could have or try to bring criminal and civil liability claims against you. Fair Labor Standards Act, like you mentioned, Internal Revenue Code violations are a potential risk there. They could basically argue they've been denied certain protections that are due to them, like minimum wage, overtime payment over the years, unemployment insurance, workers' comp. Say they were injured while they were working as an independent contractor, but in reality they were an employee. So here they are paying something out of pocket when really it should have been covered by the employer. So you really want to tread carefully. If you're not sure where somebody falls, you really should consult legal counsel on this, because it's better to get it right, or it's better to get it wrong and admit that there's risk and assess it and nip it in the bud early and fix it. So
My understanding, and correct me if I'm wrong though, is that if you tell somebody that they're an independent contractor, but in fact they should have been classified as an employee, there's a chance that from just a money damages situation, that person worked a lot of hours.
oh, absolutely.
And we, as an employer, always have the duty to keep accurate records of time. So if that happens, we could be in trouble because we could have to pay them overtime.
Absolutely.
And when you have an overtime claim, my understanding is that the person can claim, or the Department of Labor on their behalf, or all of your independent contractors together, even if they didn't even know about this, has one person who says, hey, all of us are going to be in a collective action against you for the last 2, maybe 3 years, saying we all owed 100 hours a week in overtime. Prove us wrong.
Yeah.
And we want double damages. And my attorney, my poor hungry plaintiff's attorney, needs his attorney's fees, which is worth even more. So we could get to hundreds of thousands or millions of dollars real quick because of unpaid time. Then our friends at the IRS might come down, the unemployment office might come down and say, you owe us a lot of money for all these people you didn't pay on, and let's dig a little deeper in your books while we're here and find something else. And the Attorney General's office just might say, you are tax cheats. You're not paying your taxes. Why not? And so there's some big time potential damages that could happen. So it's worth the investment to look at it. It's also worth it for our politician friends to kind of get on top of this and tell us what the rules are. I mean, if we're going to be held to this, end the business kind of money, because litigation on this could end your business. You're a public employer, it could end your program, right? These are major potential penalties that are out there. And we're not trying to say this to scare people. It's just the reality of life. That's the nature of the business. So lots of risks there. It sounds like we've got some pretty standard good rules, even though they keep changing a little bit of the standards, but the standards are basically saying the control, what you're doing, how you're at. We have to look at those things, and you can't just say it. You got to actually do it. You got to walk.
You got to walk the walk. Yep.
So McKenna, just to kind of finish this topic up, what do we need to do? What do employers need to do to reduce their risk of misclassification?
I think it's kind of two-part. One, knowing that there's such a high degree of risk, I think it would serve employers well to go through and identify anybody that they currently have as independent contractors and do an initial kind of audit to see, are there potentially issues here of misidentification, misclassification of these people? Get with HR, get with legal counsel, and go through and see if they shouldn't be properly classified as an employee. And the second phase is taking on new employees. Really, before you make the decision, if somebody comes forward and says, I would prefer to be an independent contractor, you really need to look through the title, and just because they said they wanted to be one, and look at the core function of what they're going to be doing, how they fit into the business, and what degree of control are you going to have over that person to decide whether it's even appropriate to have them be an independent contractor. And then again, reach out to legal counsel to have them help you identify who should and shouldn't be, and whether a certain position can be properly labeled an independent contractor.
Yeah, great advice. You know, it kind of goes back again. A lot of these laws have very similar concepts. When we were talking with Tony and Rob, one of the things that you look at is enforcement of non-competes. Is it consistent across the board? That could be a defense. If this is so important, well, why the heck didn't you enforce this on Johnny and Susie? But now all of a sudden you're coming after me. The same thing sort of comes into play here. You don't want to have employee A be an employee and then independent contractor B doing almost the same thing with the same rules, the same restrictions, the same everything, but you're classifying them differently. That's probably a telltale sign that you might have a problem, right? And so audit yourself, take a look at what you're doing, how much control are these people dependent on you? What are they doing? That's just, I mean, these are just great things to think about to make sure you're on the right side of a potential powder keg, frankly. So yeah, I really appreciate it. Thank you, Courtney and McKenna. Great information. And if anybody has any questions, obviously follow up with them.